Good morning, Madam Deputy Registrar. Please call the matter. Thank you.
Good morning, President. Thank you. Caribbean Court of Justice, Original Jurisdiction, pre-hearing review in TTOJ number 1 of 2024 between Derek Anand Ramsamooj and the State of Suriname. The members of this morning's panel are Mr. Justice Anderson, President and Presiding Judge.
Good morning, everyone.
Madam Justice Raj North Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, all.
Madam Justice Onaniwu.
Good morning, everyone.
And Mr. Justice Ebu Usuji.
Good morning, all.
May we have the appearances, please? Thank you.
May it please your honors, Mr. Justin Phelps, Senior Counsel, leads Mr. Navindra Ramnanan, and Mr. Milton Castellan for the applicant, and we are instructed by Mr. Chase Phillips.
Thank you, Counsel. I do think at this point you are the claimant since we have granted your application. Thank you very much. For the defendant? Can you hear us, Mr. Limapo?
Oh, I'm sorry. I have muted. Good morning, Your Honor. My name is Hans Limapo, and I represent the State of Suriname, defendant in these proceedings.
Thank you. Thank you, sir. Caribbean community?
Good morning, Mr. President, Your Honors. Lisa Showman, General Counsel of CARICOM, along with Ms. Radha Parmanan and Mr. O'Neill Francis and Ms. Gladys Young for the Caribbean community as amicus.
Thank you, ma'am. Do I understand that the state of Trinidad and Tobago is also online?
Yes, good morning, Your Honor. Should it please you, I am Laura Prasad, and I appear on behalf of the state of Trinidad and Tobago.
Thank you. May I inquire as to what capacity you appear as such?
Your
Are you
Honor,
thinking of taking an active part in these proceedings or not?
No, please, I am here on a watch and brief.
I see. Okay. Thank you very much. Well, again, thank you, everyone, and welcome to this pre-hearing conference. Just to rehearse how we got here, I believe there was the filing of a special leave application in May last year, 2024, by Mr. Derek Ramsamooj, seeking special leave to bring a claim against the state of Suriname. This court considered the application and granted special leave in October last year, 2024. And soon thereafter, the originating application was filed by the claimant. The defense was filed in November last year, and a CMC was held in January of this year, at which we issued certain orders timetabling the filing of documents. I gather the timetable has been complied with. We have all of the documents in hand, including, thank you, CARICOM, the amicus brief from CARICOM responding to the specific questions raised by the court. We also have in hand the witness statements, which were submitted by the witnesses to appear at trial. So that this morning, we wanted to make sure that we have everything arranged for the trial to take place on the 6th and 7th of November. And in particular, we wanted to ensure that we had the order in which the witnesses will give their evidence, that we also had agreed roughly broadly timeframes within which that evidence would be given, and also a time frame for counsel to make their submissions. Given that the matter involves the state of Suriname, of course, is an issue of interpretation, which could arise in relation to the evidence to be given by the witnesses, and we could attend on that matter as well. So we were proposing to have a look at a proposed scheduling of the evidence by the witnesses, of the oral submissions by the parties, and to ensure that you are happy with the proposals that we have for you. Of course, if you wish to suggest amendments, we are happy to consider those suggestions. But if there's anything else that you wish to have ventilated so that we are fully prepared for trial, then of course, we are happy to accommodate your views on those issues. So perhaps we should start at the end first. Aside from the timetabling of the evidence to be given by the witnesses and of the timetabling of the oral submissions and the issue of interpretation, is there any other issue that the parties may wish to raise at this point? Of course, if not now, we could always raise it later. But is there anything that you wish to raise at this point in preparation for trial? Let's start with Mr. Phelps, if we may. Thank you.
I'm very grateful to you, Your Honors. The two minor matters. The first is that I anticipate that the court will be asking me for a cross-examination estimate in connection with my learned friend's expert witness, Ms. Bruning. I merely wish to point out that we believe that the exhibits to Ms. Bruning's witness statement, witness expert report, have not been filed, and we would like to have those. And what flows from that is that it is at this stage difficult for us to give a very precise estimate as to how long that cross-examination might be. That was the first matter. The second matter is that the claimant believes, and we raise this really by way of respectful inquiry, that it may be of assistance to their honors in the circumstances of this particular case to have a brief opening that gives a zip code, as it were, to the evidence that will be given by the experts and the fact witnesses. So we're respectfully inquiring whether their honors might be minded to exercise their discretion to permit a brief opening of the claimant's case before turning to the evidence. Those are the only two matters I have, Your Honors, unless I can assist you further with any aspect of either of them.
Thank you very much. So we will come back to that in due course. Are there any other issues that parties wish to put on the table at this point? Mr. Limapool?
No, Your Honor, but I'd like to, if possible, I'd like to reply to the points raised by my learned friend.
Yes, please do.
With regard to the exhibits to the report by the expert for the defendant, please note that we have a translation issue. If I could forward them in or submit them in Dutch, that would be no problem. But to forward them in English within a time frame of 2 weeks would probably not be practicable for Suriname to do. So I'd like the court to, or I request the court to address this issue in a proper manner, please.
Yes. Can you tell us roughly how, are these very voluminous? Are they very long documents we're talking about?
Yes, especially there are several court judgments that have been referred to, Suriname court judgments, and those, well, they're not that lengthy, but per judgment maybe 10 pages, 12 pages. So in total, we're talking about probably from the top of my heart, maybe 60, 70 pages of legal English. So I'm not saying that it's not possible. I'm just saying that within the time frame of 2 weeks would be tough and probably not possible for Suriname to do.
President, if I may ask?
Please, yes.
Counsel on both sides, would it be helpful if, as has been hinted, the Dutch version or versions were submitted, and in this day and age of AI, it may be open to the claimant to use AI as a sort of precursor or initial stage for seeing what the documents are, pending the delivery from Mr. Limapool of the translated versions. Just a thought.
Mr. Phelps?
Your Honors, we would certainly be willing to explore that. I don't know whether there will be a dispute if both parties produce varying translations using different AI technology. But we do consider it to be of some importance. Of course, this is an expert report that is being put before the court, really primarily for the court's assistance. Some of the propositions that the expert makes are of importance, we think, to the ultimate decisions that the Honours would make. So with some direction from you, Your Honours, we would be quite happy to explore the use of AI to translate. It might be that we can exchange translations and ensure that neither party has a dispute over any material part of the translation prepared by the other.
If I may, President?
Please, yes.
I was thinking of the AI route simply as a facility for the claimant to be able to get ahead of the translated version and be able early or to start early on their preparation, not that there will be competing versions. The properly or the officially translated version, to my mind, would be what is submitted by Mr. Limapool, and therefore what Mr. Phelps gets in advance or resorts to in advance would be simply a matter of convenience. Thank you, Pres.
I completely understand now, and I am very grateful for the suggestion, which we will, Your Honour, deploy. The view, I suppose, is that they claim the respondent must produce a translation of the literature that the expert is relying upon. And we will have the facility of an advanced AI translation for our preparation.
May I ask, thank you. May I ask you, Mr. Phelps, when it is that you first brought to light this difficulty that you have?
Your Honour, when we were preparing for this hearing, it was recognized that the exhibits to the expert report had not been filed by my learned friend.
But that was an omission which occurred at the point when your learned friend filed his documents. So you did not notice this before?
We did not recognize it before, Your Honours.
Okay. Mr. Limapo, I believe that under Rule 5.1 of our original jurisdiction rules, you would, in these circumstances, have the obligation to produce documents submitted to court in the official language of the court. So there's a difficulty because if you have not submitted the document, then it is not really before the court. If you have submitted it, then it ought to have been submitted in English. So can you help us on that? I don't know if you're muted, but we're not hearing you. Sorry.
Sorry. Yes, Your Honor, I understand your observation. Yes, I mean, I will have this translated. It's just I'm just saying it's Suriname is always behind in this sense because we are a Dutch speaking country. It's impossible to translate everything, whereas the other side has Suriname Dutch speaking lawyers available who also participate in this meeting. But I understand the court has no familiarity with the Dutch language, so I will have to oblige, and I will, Your Honor. It's just a huge effort to get this done.
Yeah, sorry.
Is it possible that I suffice then with extracts again with regard to the judgments?
I rather suspect that the matter of the evidence you put forward is really a matter for you. And if you think that your case can be run on the basis of the abstracts to which you refer, then that would be a matter for your decision. I'm just observing that the obligation is really on you in this instance, since you are the one tendering the documents, to ensure that they are in the language of the court. And of course, we did agree on the timetable on a consensual basis, so that if you needed more time, then more time could have been carved out for you. Our brother suggested a way forward, which was the use of artificial intelligence competencies. I'm not sure whether that route is one that we would necessarily want to give our full imprimatur to, given the possibilities for hallucinations that we are all aware of. But of course, if you could both sides agree on the translation of the cases that you have in mind, that would be very helpful, and that might be able to bridge the gap. I'm a little wary of reliance on one side, and then, as the claimant suggested, there could be a dispute as to the meaning of the judgment. So is there a possibility that you could work together to find an AI-generated translation that you could more or less agree on, perhaps abstracts? And also, would you need to rely, to make your point, a matter for you as well, on all of the decisions that you reference, or would a sample be sufficient? You're muted.
Yes, Your Honor. I will have to check the statement again and provide as much as possible official English translations. And if my learned friend suggests an AI mechanism to resolve this, I have no problem to agree with him on any reputable AI mechanism. but I will have to translate it. So I would appreciate from the court the leeway to do that within the coming 2 to 3 weeks to submit those.
Sorry, I'm not quite sure. When you say leeway, are you saying that you could provide the English translation within the next 2 to 3 weeks?
I will do my utmost to do that. I will do my utmost to do that.
Okay.
But now we're
course.
already, now we're
Yes.
sorry for that, Your Honor. We're already at almost the half of October.
Yes.
So there's not much time in that respect.
Yes, exactly. And so, you know, and also, of course, in fairness, Mr. Phillips might need some time to digest the evidence that you wish to put forward. So the view put forward by our brother, if that is something that is amenable to both sides, that you could decide on the AI engine that we are thinking of, and if you think it's authentic, Mr. Limapo, and you're willing to abide by that accuracy, then that might be a way forward. I gather Mr. Phelps is willing to consider that path.
President, if I may.
Sir, yes, please.
President, I was thinking, and I think Mr. Phelps may perhaps have seized on this. I was thinking that it is the obligation of Mr. Limapo to present, since it is evidence from his side, the English translation. So if he uses an AI engine or he uses a natural person, that is entirely a matter for him and what he puts forward. So that would be his document. I was referring to the AI benefit for Mr. Phelps purely if he gets the Dutch version of the document, he could use AI to get the advantage of seeing early what on the version, the translated version that he generates is being presented. But it would be, and there would be no need for any agreement or concord between the parties as to what Mr. Limapo puts forward as his version, the version of the evidence that his expert is giving. So what he puts forward is what he says his expert is saying, and that would be, as it were, the resolution of this matter. So early preparation for Mr. Phelps by way of using AI to translate the Dutch version, and Mr. Limapo would be able to produce the version that he is saying his expert witness is rendering in the English language. I hope that clarifies for the parties present.
Yes, thank you. I think the only slight difficulty there is the possibility that there could be some daylight between the AI generated version used by Mr. Phelps and that then produced by the other side.
President, I think that would be entirely a matter for Mr. Phelps. What he produces through AI would be entirely a matter for his preparation that would not see the light of day in court or will not even be submitted to the other side.
Mm-hmm.
May I come
yes,
in?
Please.
Again, we're exploring solutions here in the circumstances of what now appears to be possibly an emergency. Whether part of that, again, it's just a solution, a suggestion for the court and the council to consider whether Mr. Phelps's use of AI to generate in translation of material, if he does that, of what he received from Mr. Limapo, and then gives that to Mr. Limapo to verify whether his translation, that is Mr. Phelps's translation, is consistent with what the Dutch version of Mr. Limapo's documents say. That may be one solution. If Mr. Limapo says yes, it can be, it could be a modus vivendi among the parties on the court to use that going forward so as to solve the problem. But of course, the difficulty arises if Mr. Limapo says, no, Mr. Phelps, what your AI generated is inconsistent with what the Dodge version says. Then we're back to square one. But if there is not that difficulty, it may be that that could be one way to short circuit the problem. Just a suggestion. Thank you.
Yeah, thank you, Judge. I think it's the same suggestion, it's just that it originates with Mr. Limapo. So that Mr. Limapo has AI generated or otherwise generated translation, which is the evidence, and he shares that with Mr. Phelps.
Right.
But Mr. Phelps, if Mr. Phelps doesn't agree with that, we have a problem. But if he
no, it's not a matter of agreeing. It's a matter of the evidence that Mr. Limapo is putting forward. So Mr. Limapo's evidence is what is in the translation. And then it's a matter for Mr. Phelps to agree, examine, cross-examine as he considers appropriate. But I like the idea of Mr. Limapo taking the first step, because as we said from the rules, that is really his obligation to produce the documents in the official language of the court. And this is a way of assisting him in doing so, which will cut down on the sort of time that he might require otherwise. I would remind us as well that the court has certain protocols on the use of AI, so that if we're going to go in that direction, in the way that we are now discussing, that Mr. Limapo generates translation by that means, then the court's protocols ought to be adhered to. Mr. Limapo, what do you think of that? If instead of seeking to have a natural person do the translation, you were to have recourse to AI in accordance with the court's published guidelines, and you're happy that that translation is accurate, and you share that with the court and with the other side, would that not represent any economy in time for you?
Chair, please, before Mr. Limapo answers that question, I just want to recall Rule 5.2 of the court's original jurisdiction rules, because it's quite clear that a document filed or served and expressed in a language other than the official language shall be accompanied by translation in English by a translator approved by the registrar.
Yes.
And so I think we should bear that in mind in considering any options that might involve the use of an AI-generated translation by the party filing the translation of the document filed in Dutch. Thank you.
Perfectly right, Judge, if I may say so respectfully. And also,
Sorry, President, I see Ms. Schumann has her hand up.
Yes, I was just commenting on this first. I'd also expect that, compliance with our protocols on the use of AI would probably assist our registrar in indicating approval. Yes, General Counsel, please.
Thank you very much, President. In an effort to be helpful, I've asked to speak. At CARICOM, we do have to deal with translations fairly often. What we do is we use the UWI, especially when it's French. Mr. President, it never takes more than a day and a half to do 6 pages to about 10 pages. If we are talking about 60 pages, it would seem to me, Mr. President, that translations should be possible, perhaps with the help of university or universities in Suriname, to get that in the next 20 days, say by the end of October. Even if weekends have to be worked, Mr. President, it sounds as though it's doable to me. Thank you, sir.
Yeah, President, if I may add, please, our sister referred us to 5.2 of the OJ rules, and at 5.22, in the case of lengthy documents, and I thought I heard Mr. Limapo mentioning some of that,
Yes.
translation may be confined to extracts accompanied by an explanatory note, so that there is a possibility as well that not everything may need to be translated. For example, in some cases, certainly in our system, we do a long introduction with background facts and so on. One may not need to translate everything like that. We may just need the actual ratio of the case. What is it that Mr. Liverpool wants to convince us about? And so I do agree with CARICOM General Counsel that this should be a matter, Mr. Liverpool, that you can do with some efficiency through the university in Suriname. But I also wanted, Mr. Liverpool, because you kept talking about 2 weeks and so on, I didn't get from you a good sense of the date that you had in mind, because that would be important. Remember, we have fixed 2 dates, the 6th and 7th of November, for this matter to be heard at the seat of the court. So, Mr. Liverpool, could you help us with those things, please?
Yes, Your Honor, I will have to check with the translators first, but I strive, yes, by the end of this month to submit. I will submit extracts of the decisions that that are referred to and used by the expert, and then by an official translator.
Okay. Bear in mind, of course, as we heard, that Rule 5, 1, and 2 could be relevant to that exercise. And if you choose to go the route of the AI, the protocols we have on AI would also be relevant. Yes?
Yes, Your Honor, but I will
Okay.
not go through the AI. I will not go through the AI. I will just have it translated and extract.
Purely matter for you.
Yes.
Purely matter for you. May I ask you, Mr. Phelps, if Mr. Liverpool produces the translation by the end of the month, would that be acceptable to you?
Your Honors, I'm not sure what choice I have, respectfully. We will have to, within the 6 days.
You always have a choice. That's why I'm asking you. Would it be acceptable to you? If it's not, we'll have to consider abbreviating the time allowed to Mr. Liverpool.
Can I indicate why it does put the claimant under a bit of pressure? These are the documents that are said to substantiate the expert opinion of Mrs. Bruning. They are documents that don't primarily concern us, but have to be put to our expert for him to assist us in the conduct of the cross-examination of Ms. Bruning. That does tend to take a little bit longer. And therefore, it would have been very helpful if my learned friend could see his way to providing those translations, perhaps in the 3rd week of October, which would give him 2 weeks from today.
Yes.
It is usual, which is why I raised the albeit rare or unlikely possibility that there's a difference in translations. It is usual that the party in an English language court would produce a certified translation, which I think is the purport of your Rule 5. And although we recognize that we have raised this for the first time at this pre-trial hearing, my learned friend would have been mindful as well of the provisions of Part 24 when he was filing the expert report, which obligated him to have before you, for your proper understanding of his expert evidence, the supporting documentation, which is the subject of this conversation. All of that is to say that is the degree of processing that these translations will have to undergo. And yes, we would rather appreciate it in the 3rd week if it was at all possible.
I think that is reasonable, Mr. Liverpool, bearing in mind where the origin of the obligation emanates, that we ask you, please, to produce the translation by whichever methodology you choose within 2 weeks. And those documents which are so produced will be before the court and could be used at trial. And documents not so produced will not be admissible at the trial. And then that will give the other side 2 weeks, I believe, Mr. Phelps, to consider the documents that you have produced. Bearing in mind, as you heard, these documents would have to be tendered to their expert witnesses. Can you facilitate the process in this way?
You give me no choice, Your Honor. It's a question.
There's a choice of not producing.
President, would that be accompanied by Mr. Limbapo sending in advance the untranslated document to Mr. Phelps? Because my reference to AI really was only so that Mr. Phelps would have sufficient lead time to have his own translation done before he gets the official document to enable his preparation. Thank you.
Yes, my brother. I see no difficulty with that, Mr. Limbapo, do you?
No, sir. I will provide the Dutch versions in a few days.
When you say a few days?
Well, latest by Monday, coming Monday latest.
Okay. Would that be acceptable to you, Justice Barrow? Because I think I get the sense. I think that I get the sense that you might wish to use your AI interests to convert the documents into English.
That would be splendid, President, and I want to assure you I would leave it entirely to Mr. Phelps to do his own AI inquiry.
Of course. Okay, so we are agreed on that. By Monday, we will have the Dutch version of the documents we are speaking about. And within 2 weeks thereafter, we will have the translated documents. And that will, I think, give Mr. Phelps, the claimant's representative, time to digest and to prepare. Thank you, Mr. Limbapo. I do appreciate the burden it puts on you, but I'm afraid that that is how the structure of the rules operate. I'm sorry, my sister, you were saying?
No, I was just saying, President, are we speaking then of the 23rd of October, being 2 weeks from today? Is that the date we have in mind?
Yes, ma'am. Is that a weekday or?
Yeah, that's a Thursday, I think. Yes, that's Thursday. 2 weeks from today, the Thursday, yes.
Yes. And not to repeat what we have gone over, but bear in mind, Mr. Limbapo, that the method of translation that you choose is entirely up to you, subject to our rules, of course. But there were some suggestions given, AI, university, and you may have your other sources. So we will leave that entirely up to you. Yes?
Thank you, Your Honor.
Okay, thank you very much. On the second issue raised by Mr. Phelps about the provision of sort of an opening to the claimant's case before we hear from the expert witnesses. I'm not sure whether Mr. Limbapo has a view on this, and thereafter perhaps my colleagues may have a view. Mr. Limbapo?
Your Honor, I think that's up to the court. If Mr. Phelps wants like an introduction, the defendant might opt also for the introduction to introduce their case. But it's up to the court.
Thank you. This is Rajnath.
It's not something that I am firmly of one mind or the other, President. I would think, Mr. Phelps, you wouldn't have anything more than 10 minutes in mind.
Your Honor, I had 25 minutes in mind.
Oh, that is, I think, where the problem would be, because we normally like to spend that first day, Mr. Phelps, once we can get through the evidence realistically on that first day. We like to spend that first day having a good sense of what the evidence is. If you wanted a very brief opening, I would say 10, 15 minutes, perhaps for the most. And then another 10 or 15 minutes for Mr. Limbapo. I imagine that is how it would work. President, we already have a half an hour cut off.
Yes.
And yeah, we have to keep in mind that we may have some witnesses virtually, we don't know as yet, and there may be difficulties and so on. So we want to be sort of practical, if I may use a term that Justice Witt would have always used.
Yes.
Let's approach this practically. Mr. Phelps, you think you would lose anything by not opening?
I think, thank you. If I may, we will come back to Mr. Phelps in just 1 minute. I do think that our brother, Justice Ibu Osuji, with his previous experience, may want to express a view. But first, Justice Barrow, then Justice Anonu, if you have a view on this, please.
Yes, President, if I may, I can see where Mr. Phelps may want in 5 minutes to highlight for the court the essence of those aspects of the case that he will be presenting, which he would want us to pay particular attention to, which he thinks that our pre-reading, which he thinks that his 40-page submission would not have conveyed. Then I can see where in 5 minutes he may want to say, at page 18 of my submissions, I emphasize this particular aspect, etc., etc. But to give the full opening to the jury before you present your case is really, to my mind, not necessary at this level. And I can see where at the opening or the commencement of the case for the State of Suriname, they may also want to have 5 minutes to give some introduction to those particular aspects that they think we need to be guided to pay particular attention to. But really, I do not see where there's a need for this court to be given anything more than simply particular highlights that counsel thinks it is important that we should be highly focused on. Thank you, President.
Thank you. Justice Anonibu?
President, I similarly think that there wouldn't be a need for the claimant and certainly not the defendant to be afforded 25 minutes to provide an opening. I agree with Justice Barr that there may be some value in spending a short amount of time. I agree with Justice Rajanath Lee. I can't see why it would need to extend beyond 10 minutes to properly contextualize the case that is going to be presented, first through evidence and then submissions. And so I don't think that there would be need for the allocation of as much as 25 minutes to that if it is agreed to. Thank you.
Yes, thank you.
My own intervention, Mr. President, runs along the same lines as what my colleagues have said. Justice Barrow in particular usefully made reference to jury trial. We have to remember that this is not a jury trial, and we have documents already filed by the parties, a statement of claim, the pleadings as it were. So we have, the court has a sense of what the case is about. So it will be a matter of synopsis, if need be, for parties, and I think that could be done in 5 minutes or even less. But so I do think I see Justice Rajanath Lee's difficulty. I'm with her on that. 25 minutes will be too much for the exercise in question.
Shall we say not exceeding 10 minutes?
President, your usual generosity prevails.
In 5, but
I thought I was learning from you.
In my view, in the circumstances that the materials are already before the court. Yes. But I'll leave that to you.
Okay, so Mr. Phelps will say not exceeding 10 minutes. We, as you would have heard, are thinking that 5 might be sufficient, but in any case, not more than 10. And we'll afford the same courtesy to Mr. Limapool if he wishes to avail himself of it.
I am very grateful to the court.
We're grateful to you too. Okay, so I think we could then move on to the timetable that we are proposing. May we inquire first of all, though, and Ms. Tukey will assist us by putting up the proposed timetable, or judicial counsel. May I inquire about the witnesses and whether they will be all here in Trinidad at the seat of the court to give their evidence? One, and secondly, whether in your view it's likely that they will require the assistance of interpretation services, or we would require those services to follow. Can we start with Mr. Phelps, please, on those two issues?
I beg your pardon, Your Honours. We have all of our witnesses in person except Dr. Clegg, in respect to which there is the added complication of a time difference. Dr. Clegg practices in the United Kingdom. He is asking for your accommodation in taking his evidence at 2 p.m. or Trinidad and Tobago time on either of the days that you have set aside for trial. Subject only to Dr. Clegg, all of our witnesses we expect to give evidence in person.
Okay, and do you think we would need interpretation services for any of them?
No, for Mr. Dubois is the expert. He is a Surinamese practitioner, and he may need an interpreter.
Okay. All right. Well, as our sister mentioned earlier, we're hoping to have the evidence on the first day. So that would be, I think, on the 6th of November. And we will seek to accommodate best we can the time constraints that you indicated. Mr. Limapool, same questions, please. Are your witnesses likely to be, I think you have two witnesses. Are they likely to be here at the seat of the court? And would we need interpretation services in relation to either?
Yes, Your Honor, I expect them to be in Trinidad and Tobago physically. And yes, they will need interpretation services. Okay. They will only give statements in Dutch.
Yes, thank you very much. And as is our obligation under the rules, we have made arrangements for the provision of interpretation services. I believe that you have been in touch with our registry so that you're familiar with the interpreters we have in mind and that you have no difficulty with them. So that service will be available when needed. Thank you again. Unless there's any further comment, could we then go to the proposed schedule? Ms. Dookie, please.
President, if I may, before we go through the timetable, I will have to amend the times, but the period will remain the same. Well, our proposed period, so 60 minutes, 15 minutes. I will now have to add in time for the opening statements, and I will also move Dr. Clegg to 2 p.m. on this day. So there will be some rearrangement, but the period of time, for example, 60 minutes, 45 minutes, 15 minutes, that would be the proposed period.
Thank you. So with those observations then, the question is whether the proposed timetable is acceptable to the parties. And of course, we are happy to entertain any suggestions for amendment. We would start on the first day with sorry, Mr. Phipps, were you thinking of the opening statement right before the first witness or before the expert witness?
At the very beginning.
At the very beginning. Okay, so we'll build in the agreement we have about the opening statements, and then we will go to Mr. Ramsamooj, and the proposal is that the giving of his evidence and cross-examination would occupy 1 hour for the most. These are intended to be, outside limits. Could be less, could be more as well if you think we need more time to be allotted. So could we pause there? Is that appropriate, sufficient in your view? I imagine that the examination in chief will be very, very brief. It's simply a matter of tendering the witness statement and having that verified, authenticated by the witness. So most of this would be the cross-examination and very brief re-examination. So what do you think? Claimant? Defendant?
We have no objection to the timetable as it is, Your Honor.
You're thinking of the entire timetable or just Mr. Ramsamooj?
All that is on the screen at the moment, which is Mr. Ramsamrooj, Ms. Paggi, and Dr. Clegg.
Okay, wonderful. Mr. Limapool?
We have no problem with the suggested schedule, Your Honor.
Excellent. I should have asked whether CARICOM wished to make an intervention at the opening as well.
Very kind of you, Mr. President. No, I don't think we will need to at all.
Thank you. All right, so we then have lunch, and then you see the next round to complete the day, subject to the modification mentioned by Ms. Dookie. Du Bois, Ramprasad, and Bruning. And those are the times we have proposed, 60 minutes, 45 minutes, and 60 minutes. Is that acceptable?
President, I'm wondering if, given that Dr. Clegg would be in the afternoon, if we should be considering, and it's entirely a matter for your guidance, starting the defendant's case before lunch and interposing the claimant's Dr. Clegg witness in the afternoon, given his evidence will have nothing to do with, as it were, the legal issues or the factual issues in this matter, so that his being in that afternoon slot would not disrupt the flow of proceedings. Thank you.
Responses?
President, if I may just respond to Justice Barrow on that. One of the, well, my proposal was to switch this expert with Dr. Clegg, so just to rearrange these two.
So that there be no break in the claimant's case?
Yes, please, okay. President.
Yes.
That sounds perfectly fine, President.
Wonderful, thank you. Sorry, did we get the agreement of our representatives to this segment of the proceedings? Mr. Phelps, is this okay?
Your Honors, for the claimant, the only observation that we would make is that the cross-examination of Mr. Ramprasad is very unlikely to take as much as 45 minutes. Yes. I would estimate it would take 20 minutes or so at maximum. So assuming that my learned friend did not do more than put in Mr. Ramprasad's witness statement, there are 25 minutes there that would perhaps make the claimant's deficit good, as it were.
Excellent. Thank you. Mr. Limapool?
Well, Your Honor, why would we change it? Why would we change it? 45 minutes seems, I mean, the cross-examination might not take long, but maybe the examination in chief might be take a little bit longer as a consequence of the earlier statements by the claimant's witnesses.
Well, as we, I think, indicated earlier, normally the examination in chief is simply the tendering of the witness statement.
Yes,
so,
Your Honor.
Yes.
30 minutes would be fine. 30 minutes would be fine.
Okay, it's fine. So we'll make the adjustment. There being no other observations, could we then go to day 2, please? Yes. So we are proposing that counsel for the claimant makes submissions for 90 minutes. Have a short break, and then counsel for the defendant, 90 minutes. And then the amicus for 45 minutes after lunch. And then we have the wrapping up first by the defendant, 15 minutes, and then the claimant for 45 minutes. Any observations on this? Yes, please. GC.
At the risk of sounding too modest, Mr. President, I think CARICOM, unless your honors say otherwise, probably won't need more than half an hour.
30 minutes, yes. Of course, you would be open to questions by the parties, and therefore it may be a little bit, as you say, ambitious to estimate the time that will be required for the community. So why don't we leave 45 minutes and see how we go? If you're generous with us, then that's great. Okay. Yeah. Other observations? Are you happy, Mr. Phipps?
Your Honours, the only inquiry that I would respectfully make, please, is whether the parties are free to supplement what might be said orally by any written argument before a deadline set by you.
Justice Ratcliffe, I don't think that is our usual practice. We have your written submissions, we have your witness statements, we'll hear from the witnesses, and then you have an opportunity to make oral submissions. I don't recall that being a practice that we have engaged with before. Do you?
No, my recall is the same as yours, President. Generally, we've not had that situation at all. There may be very exceptional circumstances, but Mr. Phelps, I think it'd be difficult to predict that at this stage.
Yes.
I think
I think we would stick with the tradition, unless, of course, as the judge indicates, we need to change. Already you have very helpfully introduced a new change for us, the opening statements. So let's move forward incrementally, shall we? Right. Well, I think that those are the issues we wanted to raise with you. You have indicated others which we have dealt with. Are there any residual matters that we need to deal with?
Not for the claimant. Thank you, Your Honours.
Thank you, sir.
Not for the defendant, Your Honor.
Thank you, sir. Yeah. And amicus?
Nothing from your amicus, sir.
Thank you very much. And I see you've been faithful to your watching brief, Trinidad and Tobago.
That's nothing from us. Thank you.
Thank you, ma'am. Okay, well, thank you all very much, and we look forward to seeing you at the seat of the court, 6th and 7th of November, and to trying this matter at that time. Thank you all very much. Madam Deputy Registrar, please.
Thank you, President Anderson. Thank you, Madam Justice Rochnotley. Thank you, Mr. Justice Barrow. Thank you, Madam Justice Ranu, and thank you, Mr. Justice Ebosuji. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.